Start the recording. Good evening. Welcome to United Policyholders webinar on deadlines and decisions at the first anniversary of your wildfire loss. My name is Amy Bach. I'm so pleased to be joined this evening by a volunteer expert, an attorney by the name of Jacqueline Conover. Jacqueline, welcome, and thanks so much for joining.
Hi, everybody.
So I'm going to start the PowerPoint and remind everyone that you don't have to worry about taking notes. We are recording the session and you will be able to watch it at another time if you forgot something or missed something. First, I, of course, want to say that we're very sorry for the circumstances that brought you here this evening, but we're so glad that you found United Policyholders, and we're so grateful to the funders and volunteers that make it possible for us to bring our Roadmap to Recovery program services to regions that have been impacted by wildfires. And no one who has gone through a wildfire ever feels lucky, but particularly when you have been impacted by a disaster that was not a mega disaster, there's often not as much attention and resources available to you. So we are particularly pleased to be able to support your recovery. A reminder that we're a 501c3, meaning we're a nonprofit. We focus on disaster preparedness and recovery and insurance matters. We do not take funding from insurance companies so that we can give you the straight scoop and be independent. We're funded by donations and grants, and we work around the country with a special focus in California. Team Up includes our professional staff. I want to acknowledge Carolyn Winter, who's with us tonight recording and who is responsible for having done the publicity that brought you here. Our government, business, and nonprofit partners, and our volunteers. Our volunteers include people like Annie Barber, who you may already know from Survivor to Survivor, or from a long-term recovery group or some other forum where you may have met Annie, or Val Brown, who you may know. Then we have our consumer-oriented professionals who help us bring technical information to you and stay current as things change in the marketplace. Jacqueline is one of our attorney volunteers. Her law firm has been a friend to United Policyholders for many years. So we are here tonight through our Roadmap to Recovery program, focused on helping you continue putting one foot in front of the other on your journey from having lost your home or having had your home damaged to being able to either move back in or resolve your insurance claim and replace your home by buying somewhere else. Hopefully you're already familiar with the free library that we make available to you, that we keep updated as best we can online. A reminder that tonight's workshop is intended to be general guidance only, not legal advice. If you do have a specific legal question, we recommend you consult an experienced attorney. We offer a directory on our website, the Find Help directory, where you can find the professionals who support our work. We don't endorse or warrant any of the speakers at our workshops or our sponsors, and we're not creating a attorney-client or professional-client relationship here with you or with anybody that we help. So I already introduced myself and Jacqueline. And this is a little bit more about Jacqueline and with her background. And Jacqueline, you've been assisting California homeowners with insurance matters for quite a few years. How did you get into the business?
I was originally on the defense side for about 12 years. So I represented large insurance companies, a lot of homeowners policies, but also commercial general liability policies. And I did not find that particularly fulfilling. So I found Cantor and Cantor, actually, they found me. And I've been working with the Cantors for about 3 years now.
Great. Okay, so we're going to cover best practices, deadlines and decisions, loss of use ALE, your contents claim, troubleshooting. We will answer questions that come in during the program. And if you do have a question you want to ask, you can use the Q&A button on your Zoom toolbar. And then we will talk a little bit about observing the anniversary. So, as you probably have heard or may already be experiencing, although it's a little early, disaster anniversaries tend to bring up emotions and renewed anxiety. So we recommend just recognizing that, rereading your policy to double check the math. Did your insurance company adjust your limits if you had an extended replacement endorsement, or you had building code upgrade endorsement that gave you extra coverage, just to make sure that you are playing with the full deck there, that you actually know what the maximum benefits are that are available to you. We also recommend that you request a complete claim summary of all amounts you've been paid to date, and then correct any errors in payments or allocations to the different buckets of coverage. We also recommend that you organize and turn in receipts for any of your additional living expense, loss of use, temporary rent benefits that you have not, receipts that you haven't already submitted. And then finally, we always recommend communicating with your insurer in writing to get confirmation that there are no policy deadlines you need to comply with at the anniversary. And so we're going to go through some of the deadlines that may be in there, but also a few more suggestions. So the reason that we focus a lot on how important it is to journal, to keep an ongoing record, and to have a paper trail, is that it tells the story of how your insurance company handled your claim, and it helps you recognize if any balls have been dropped. And that includes getting an extension on any of the deadlines that your insurer says apply. And generally there shouldn't be anything for you to be worrying about now, other than a proof of loss deadline if your insurer has asked you for that. But as far as your inventory form, if you're working on your inventory and your insurance company says, well, you need to complete it within a year, then you need to be asking them for an extension. And if they say no, then you contact the California Department of Insurance to get their help. This is just a sample of how you can log contacts and journal so that you have a nice timeline history of who said what to who when, and also confirming how you've been cooperating. We offer a free accounting spreadsheet on our website. You can see the link there to get to it, so that you can figure out, okay, what have I been paid and in what category. We always want to keep your focus on reaching a reasonably accurate understanding of what your as was rebuild costs will or would be. And that's the basis for reaching a fair settlement on your dwelling claim. The same goes for a partial loss, getting a reasonably accurate understanding of what work has to be done to restore your home to its pre-loss condition, and how much is that going to cost. And obviously most people, I'd say 100%, want to max out their contents coverage payouts. And then also do your best to get second opinions on what your insurer has calculated. So Jacqueline, United Policyholders does surveys after wildfires and other disasters. And we have come up time and time again for many, many years with the same statistic from the survey results, that approximately 2/3 of the people who lose their homes in wildfires are underinsured, so did not have enough coverage on their dwelling to put it back the way it was. So can you talk to us about how you have seen this as an attorney, and whether you have counseled underinsured disaster survivors who on strategies?
Sure. Unfortunately, like you said, Amy, this comes up all too often. If you are substantially underinsured, the first thing that you want to ask yourself is, what had been communicated between the insurance agent and myself prior to the loss? So, if you had no real involvement in the procurement of the policy, if you never reviewed the policy prior to the loss, if you didn't know what your coverage limits were or how much it would cost to rebuild, we've seen that it's very difficult and unlikely that you'll be able to convince the carrier in retrospect to increase your coverage limits after the loss. But if you had communications with your insurance agent that show that you asked for a specific coverage limit or an increase in coverage, or perhaps you explained that there were renovations or updates to your property and you asked your agent if you needed more coverage, you may be able to bring a lawsuit against the agent for negligence and against the carrier for reformation of the policy. So reformation of the policy it basically means that the carrier is going to amend the policy for the year that you had the fire or the loss to reflect what was actually agreed to between you and the agent at the time of the inception of the policy or at a policy renewal, when the agent should have originally done that. These cases are difficult and they're hard fought, but they're not impossible. And I would encourage you to kind of go back and look through any kind of email communications, any recollections of conversations. Even some people go through their phone records to see if they know for sure that something happened with their agent. They can at least pin down a date that they spoke to the agent. You can subpoena records that show that the agent's file saw that you called. And sometimes you might not have those records, but somebody else does.
Yeah.
If the reality of the situation is that you're underinsured and you don't think you have the goods to sue your agent or your carrier, you should determine whether it makes sense to rebuild or take a payout of a policy and move somewhere else. While moving away from your home is not always an option for everyone, if it is an option for you, I think it's something that should seriously be considered. In my experience, our clients who are able to do that are able to start fresh and then pursue the carrier on the back end once they have a stable living environment. It turns out to be a little bit easier just because the rebuild process can be difficult and long. If you are underinsured, you might have to secure an SBA disaster loan or other funding, which can take time and tie your hands. But obviously, again, sometimes it's just not an option. But if you are substantially underinsured and you have communications and you think that is substantial enough to potentially bring a lawsuit against the agent or the carrier, you should definitely consider consulting with an insurance attorney.
Yep. And just, I just want to make sure I explain a few terms that you use. So when Jacqueline says carrier, she means insurance company. That's a term of art. And the reformation, which she explained well, that would just be for them to say, okay, your policy limits were, let's say, 500,000. If they retroactively reform the policy, let's say to 700,000, very often they will say, okay, we're going to do that, but you just have to pay the difference in what the premium would have been. I mean, that's sort of the best case scenario for most people, like, oh, fine, I'll pay the difference. But as you heard Jacqueline say, it really is a fact specific kind of a decision, meaning when she said if you have the goods, what she meant was if you have some evidence, if you have phone records, if you have a pretty clear memory of the details of a conversation that you had where your insurance company very clearly reassured you that your limits were adequate, and based on that reassurance you rested easy thinking, well, I don't need to do anything because I'm fully insured. So that's one of the reasons why we talk about keeping up the paper trail, is because it's always important that you be cooperating, and that you are the one wearing the white hat. You are doing everything right, and you're confirming that. And then you're telling the story of how they're behaving through your communications, right? This will confirm that on such and such a date, I made myself available for an inspection. Your guy didn't show up. Nevertheless, I'm willing to reschedule, that kind of thing. And then politely reminding them that you have been out of your house now for whatever period of time, and that you're under significant stress, but you are working very hard, to move things along and to get them anything that they need. We do recommend letters be short and sweet, and that you avoid venting. First of all, the insurance company didn't start the fire, but more importantly, you want them to read the letter. You want them to see you as a professional person who's there to get things worked out. So your paper trail gives you negotiation leverage. We mentioned here that if your insurer has been rotating adjusters on you, if they've given you more than 3 in 6 months, they're supposed to give you a status report. That's California law. And having that journal, that claim diary, helps you to go back and say, wait, didn't they say they were going to get back to me on my inventory within a week, but it's been however many weeks or months. So, what's reasonable? There are laws in California. There are regulations that say how many days the insurance company has to respond to you. Very often they go beyond those dates. And so, for example, Jacqueline, I think, some conduct by an insurance company, let's say they don't write back to you, within 15 days, or they don't pay or deny within 40 days. Some of those things are kind of like, well, there's good reasons for them, but sometimes there's not. How should a consumer evaluate what's reasonable in terms of if an insurer has gone beyond a deadline, that they've blown a legal deadline?
So whether it's reasonable, they're statutorily required to respond to a communication from the claimant regarding the claim when it reasonably suggests to them that an answer is warranted. So basically, if you sent an email to your claims adjuster asking a question about coverage, under the Fair Claim Settlement Practices regulations, they have 15 days. They should be responding within 15 calendar days. If they are taking 30 days to respond to you, my suggestion is this. When you send an email that warrants a response, you should calendar 7 days out for yourself and send a follow-up email suggesting that, I'm looking for a response to this. If you don't get it in 15 days, remind the carrier remind the adjuster it's been 15 days. I deserve a response. Could you please respond? You always want to be kind and professional as possible. But what is reasonable is subjective. If the carrier is getting back to you, if the adjuster is getting back to you saying, I'm really sorry, I can't tackle this at the moment, but it's going to be on my plate next. I've got 30 other things. It's more about how much you're communicating. You want to make sure that you've made the effort and that you can leave a clear paper trail that you've attempted to communicate with your claims adjuster and they're not getting back to you. And that at some point it does become unreasonable when you keep asking and getting nothing back.
Right. And so thank you. So yeah, not every delay is going to really make the insurance company look like a bad guy. It's just it's reasonableness, right?
And when it comes to a standard for the insurance company acting in bad faith, while it sounds crazy, they can violate some of these fair claim settlement practices regulations and still not, it can still not amount to them acting in bad faith, right? There has to be something a bit more than that, despite how frustrating it is.
Yes, and that's a hard one for people, I think, because you know, you feel like, well, aren't those deadlines there for a reason? And you know, why would a court let them get away with it? But insurance companies can be pretty good at coming up with excuses and all that.
Sure.
So we say on this slide, we mention, how does buying change the situation? What we mean is, if you've decided that you're going to buy instead of rebuild, that's definitely going to, it shouldn't change the situation, right? Because in a way, in terms of how quickly the claim should get resolved, right? The insurer has a absolute clear, as we say in the law, affirmative duty, meaning they just can't sit back and say, oh, well, you know, well, this thing will get resolved, right? They're supposed to bring about a resolution of your claim. That's part of their job. And so Jacqueline, how can your paper trail document ensure delays or unfair conduct, and how can that increase your leverage to get a settlement? Because I think, just to go back to that slide for a minute, we say ask for a cash out. It's a gamble, but it can provide a set amount. What we've seen sometimes is, if somebody has a pretty good paper trail that the insurer has been dragging their feet, and there have been multiple adjusters, and every time a new adjuster comes in, the person has to start from scratch, how can that give them leverage to maybe say to the insurer, all right, we've had it, you know, we would like to not have to hire a lawyer here, that X dollars will wrap this up? Is that a viable strategy for some people in certain situations?
Yeah, it can be putting together a package of all of your communications with an adjuster can eventually get up to higher ups at an insurance company who are going to take a look at this and say, wow, we did not follow the regs here. We did not act in a way that gave this person enough coverage and enough time, and these delays are egregious. If it gets any further, we could expose ourselves to bad faith. We should just pay this now. Sometimes it's not the adjuster. It's got to get in front of somebody else, which could be a legal team within the insurance company. Even requesting the claim file, demanding a copy of your claim file can bring certain attention to your claim. Yep. So it's really important that you document things well, that you pay attention to what you're putting in writing yourself, because you might wind up being a witness in your own case, and you want to be very mindful of that.
Yep. Okay, so policy deadlines vary from by company and policy form. Some of them get extended by California law. In California now, we have a 24-month suit limitation. And so, you know, one of the reasons that we mention that, and here we are, you know, the title of this program tonight is Deadlines and Decisions. Those of us who are lawyers are very, we do focus on deadlines for filing a lawsuit, because forever and ever, insurance companies, insurance policies have had a 1-year suit limitation in them. And lawyers like us have argued that there are reasons why the person didn't file suit, you know, within that year, and that they should not be barred from using the court system. And so then the legislature said, all right, we're going to make it a little clearer even. Jacqueline, should people be worrying about the statute of limitations now before the 1-year anniversary in California?
Not right now. I mean, luckily that should be one thing that's off of your table of worries. There shouldn't be any issues with having a 1-year statute of limitation anymore.
Okay. And so deadlines that should not matter yet: your additional living expense, ALE. You have 36 months to use that category of benefits. Loss of use, temporary rent, insurers used three different or more terms to describe the same thing. It's the coverage for the expenses that you incur because you've lost the use of your home. So you shouldn't be worrying about that. You should not be worrying about collecting replacement cost value on your contents or on your home. You have up to 36 months in California for that as well. And you shouldn't be worrying about filing a lawsuit for bad faith. So Jacqueline, what is bad faith?
So bad faith is when the insurance carrier acts in a way that is contrary to the insured's own rights. If they're putting their rights above and beyond the rights of the insured, that can be an example of bad faith. It is a cause of action that we bring in a lawsuit. So it's the breach of the implied covenant of good faith and fair dealing. It is a long-winded way of saying bad faith. So typically, if we reach a point where the insurance company has handled your claim in a way that is egregious, right? We would request a copy of the claim file. We would take a look at that claim file. If we believe that they breached the policy and acted in bad faith by not paying your benefits or delaying benefits, typically we bring a lawsuit, and that is for breach of contract, meaning the insurance policy, and breach of the implied covenant of good faith and fair dealing, or bad faith.
So basically we're saying if you breach a contract, you have not lived up to your obligations under that contract, right? For bad faith, it's like it's you did that, you breached the contract, and you acted really badly, right? So
right, and there are different remedies for that under the law. So the breach of the contract itself means that you're limited to the policy terms. So if you had $300,000 in coverage A limits, that's what you'd get under a breach of contract. Bad faith can open the door to what's called extra contractual damages above and beyond what was set forth in the contract.
Right. So, in United policyholders, we're not, obviously we're not pro litigation, we're not anti litigation, we're pro policyholder, meaning whatever's going to get you from point A to point B is what is the path we want you to take. But we also, the reason that we hold these webinars and we invite lawyers to come on is that we are very aware of that it's not really a level playing field when you're talking about you versus a big insurance company. And we know some of the stuff that goes on in the claim scenario. And we kind of, we want to make sure that you understand that you have rights and that it is possible to hire a lawyer and to file a lawsuit and get a settlement with an insurance company, or even if you have to go to trial, and you can hire a lawyer without paying them by the hour. You can hire them on a contingent fee basis. And a lot of people don't know about that. A lot of people think, oh, well, I can't afford a lawyer, and but I do feel like I'm not getting treated fairly. So part of our job is to explain to you that there is such a thing as insurance bad faith in California, and that you can, because you can recover not just what the insurance company owed you, but also the extra harm that they caused to you through their conduct, and that there are lawyers that specialize in that, and we know a lot of them, and Jacqueline is one of them. Her firm Cantor & Cantor is one of them. So what we're doing here is just exposing you to the information. We are not here to say, oh, you should run out and hire a lawyer, because frankly, you may not even have a really good case, but you really wouldn't know unless you think it through and get educated, which is why we're here, and you make a good decision. And Jacqueline and I were talking before we started tonight about how when you're getting to that 1-year anniversary and your mind is kind of maybe going to that sad place again of like, why did this happen to me? you know, that one of the things that people really want to do is move forward and get closure. And you know, if you have had a really rough time with your insurance company, and it's been kind of going on and on, there's really no reason to kind of let that keep going. And even though the statute of limitations is not an issue and you're not facing a deadline, you know, it may still be worth talking to a lawyer now just to make sure, because again, the idea is to get through this as quickly as possible in terms of putting your insurance claim piece behind you, and you know, getting all the dollars that are available so you can make whatever decisions you want. So deadlines that may matter at the 1 year anniversary would be submitting proof of your losses. And so that's what you want to clarify with your insurer, whether or not they're going to hold you to any kind of a 1 year deadline to submit your inventory, as we mentioned earlier. A lot of people have been taking advantage of the California law that requires your insurance company to pay you a percentage of your benefits without having done an inventory, right? It's a percentage of your dwelling. That's the way we did it, your dwelling benefits. That's how we did it in California. In Colorado, disaster victims can get an advance of a percentage of their contents benefits, which is a little bit more intuitive. That makes sense. If it's an advance for my contents, it should be a percentage of my contents benefits. In California, the advance on your contents actually is tied to the amount of dwelling benefits, and that was an intentional change in the law that to give you extra money, because most people have a lot more coverage for their dwelling than they have for contents. So if you took advantage of, as most people do, of the percentage of advance, but you still have to do, your insurer is still requiring you to do an itemized inventory, you really do need to get that confirmed with the carrier that your contents claim is open and you're continuing to get that itemization done, which for a lot of people goes on well past the 1 year. So Jacqueline, what if you're underinsured and you think it was an agent's fault? Do people need to worry about that at the 1 year anniversary, suing an agent for misleading you on the adequacy of your coverage?
So there could be a 1 year statute of limitations for suing your agent. So you do want to pay close attention to that. Typically, we lump our lawsuits together with suing the insurance company as well. So we'll sue the agent and the insurance company, and you have more time to sue the insurance company. But if you're a year out and you already know that you had communications with the agent a couple years ago, there's no reason to wait. You want to do it as soon as possible.
Right. Okay, so the proof of loss provision lives in the conditions section. You know, really, I don't mean to make too big a deal about this, because you just want to make sure that you have clarified with your insurance company. They extend those deadlines all the time, but it's a good idea to request the extension in writing. We offer a sample letter to help you do that. Again, if you have replacement value coverage, you've got up to 3 years to claim it. But one thing that people run into still is, in California, if you have replacement value coverage on your dwelling and you suffer a total loss, you can take all the benefits that your insurer would have owed you to pay for a rebuild, and you can use that money to purchase a replacement home wherever you want. And they have to basically give you the same amount that they would have given you had you had done a rebuild. That includes buying that. So your choices in California include rebuilding your home at the current location, rebuilding at a new location, or buying an already built home in a new location. Because we're one of only a couple states that have that rule, a lot of adjusters don't know about it, right? A lot of adjusters come from other states, adjusters that insurance companies hire, and they don't know that California has that law. And so they will say, well, if you're not rebuilding, you only get a depreciated value. That is not true. So we have a good publication that explains this to you. Another thing that adjusters may say that is wrong is that we get to deduct the value of land under the home that you want to buy. And again, our statutes very clearly say that a deduction for the value of land at the new location shall not be permitted. Where people get into trouble all the time is they skip a step, and that step is they didn't reach an agreement with the insurance company on that as was what it would have cost to rebuild the home. And so when they tell the insurer, oh, I found a house I'm gonna buy, and it's 3 bedrooms and the old house had 2 bedrooms, the adjuster may balk and say, well, you're trying to get a better or bigger house. And in fact, if the house you want to buy costs the same as what it would have cost to rebuild the home you had, it doesn't matter whether it has 3 or 2. It just matters that it costs the same, right? But again, because this is still a kind of a new law, there are kinks that need to be worked out, but we're here to tell you what your rights are and what the law is, okay? And our recommendation is that your budget for buying a replacement home should be based on an agreement that you reach with your insurer on that theoretical cost to rebuild the old home. And that should include architect, engineering fees, permit fees, subcontractor fees, materials, code upgrades, if you have that coverage, and labor, including overhead and profit. And, before we all take a deep breath here, I want to explain that we understand that that's a tricky thing to do, to reach that agreement on this fictional project that you're not going to actually do. Insurance adjusters will throw an exactament estimate at you and say, this is what we owe. And of course, as we say, computers don't do construction, contractors do construction. So what matters is what you would have to pay in the real world, not in the imaginary exactament or Symbility computer estimate world. So we're just take 1 minute here and relax the shoulders and take a good deep breath. Okay, moving on. ALE, loss of use, additional living expenses. This is the law, giving you the three years. It's not automatic. You've got to provide documentation as to why you haven't been able to move back. And of course, for people who have a dollar limit in their policy for ALE, which is most people, you need to make sure that you're stretching it out and budget as best you can. Coverage for this category varies. You may have a dollar limit, you may have a time limit. It can't be less than 36 months in California. You may have both or neither. And then your coverage determines how your insurer will handle it and for how long. This is a quick snapshot of where you'll find it by now. I'm sure you're familiar with that. But here's an example of a State Farm policy that pays actual loss sustained. It doesn't actually say how much you have. So in that situation, you've got to just continue providing proof that you are incurring expenses. And that's those receipts we talked about earlier. There may be a different standard in your policy. Again, by now, you're almost at 1 year. I'm sure that you all have a pretty good idea of what your insurance company owes you. But it might be fair rental value, or it might be the actual cost that you're incurring. For a lot of people who have a second home to live in, or they can live with a relative, they want to negotiate fair rental value if they're not paying rent currently, that they can submit a reimbursement for. Okay, so we hear a lot from people who say my insurer is jamming me, they're pressuring me, they're telling me I should be making more progress, I'm doing the best I can. And this is another example of where you just need to have a good paper trail that shows that you're doing your best and you're trying to move forward. And if there are reasons why your rebuild or your replacing your home has been delayed, just make sure that you've laid those out in writing, right? Okay. What if you have to stretch your funds? We recommend considering things like buying a tiny home or an RV to put on your property, or asking for a cash out or asking to switch from to the fair rental value calculation. These are some of the common reasons why people need to keep collecting their ALE. Hard to find, help could help us in high demand and short supply. Cost increases, the insurer has delayed, you didn't know how much money you had for your budget to rebuild, so you've been sort of left in limbo. All right. What if my policy has a max dollar limit for ALE and I'm worried I'm going to use it up before the 3 years? We offer a sample letter for asking. My basic feeling is I don't think you should be worrying about that now. You're only at the 1-year anniversary. Jacqueline, do you have anything to add on that?
Yeah, I mean, it's a hard position to be in because it's one of those things that'll keep you up at night. And I've seen people liquidate their ALE way more quickly than they would need to. I mean, there are certain things that you want to be considering if you know that you haven't made a whole lot of progress this year, to try to budget for the next 2 years. One of those things I think you mentioned, Amy, was to ask for a cash out so you can manage your own expenses. You want to look for long-term versus short-term rentals, look for local rental agencies as opposed to like an Airbnb or a VRBO, which is sometimes more popular. They jack up costs. The more control, planning, budgeting that you have over managing your ALE, the better. To the extent the insurance carrier caused delays in getting you money to rebuild or was being disruptive with the timeline in terms of contractors, there's an argument if you get into litigation that they drained your ALE by failing to timely pay or handle your claim. So that's why it is important to document those delays. If you talk to the contractor and an insurance adjuster stopped work or communicated in a way that caused delays, you want to get that in writing. One other thing that I see often that I just want to mention briefly is pet boarding. Typically you can use your ALE to board your pet, and long-term pet boarding is insanely expensive and it does drain your ALE. And I know so many of us are just animal lovers, and it can be really hard to find a pet-friendly rental. But one thing that people don't do is they're afraid to ask. And you have to advocate for yourself in every respect. So you have to ask a landlord that says no pets, if he's willing to meet your pet, if he's willing to get documentation, anything to save you money, because I've seen people spend $30,000 on boarding their pets in a not great situation anyways, when they could be living in the rental with them had they just pushed a little bit more. There's also other options, just like reaching out to your local pet rescue organization or the ASPCA to see if they have anybody that will do just like to temporarily take care of your pet or foster them for a little bit. But you want to be as savvy as possible and in control as possible of that ALE money, because nobody wants to be losing sleep at night wondering if they're going to have enough to last them through their rebuild process.
Yeah. Oh, excellent points. Okay, so your contents claim, you can use our resources. We have worked really hard over the years to offer as much free help as we can to help you get through this, what's pretty much painful for everyone. I always say that think that the mind, the heart and mind work together to protect you. And when you have something painful, like the fact that your cherished photos and gifts people gave you over the years are gone, there's I think the body tries to make you forget those things, right? To protect you. And so, trying to force yourself to remember all the things that you don't have anymore is really, really devastating for a lot of people. It takes people a long time, which is why to do, an itemized inventory, which is why United Policyholders has worked so hard over many, many years to try to make it easier for people to get their contents benefits without having to do the inventory. We have lobbied for legislation. We helped get the 30% of your dwelling limit bill in effect. We tried to get 80%, get the law to be that the insurers had to give you 80%. We couldn't even get it done. But be that as it may, we offer all kinds of resources to help you, and we occasionally host pricing parties, which some of you may have already taken advantage of. These are the things that you can use online from our website. Okay, so observing the anniversary. This is now your new normal. Your loss and the recovery is now a major part of your life. Don't shy away from seeking professional help. It can make all the difference. This is not the time to tough it out if you're suffering from depression or anxiety related symptoms. The goal is to incorporate this experience into your life and your family's legacy and make a new normal for you and your family. And these are some of the really hard things for us to help people with. But because we have so many people involved with our organization who've been there, done that, lost a home, got some help from us, volunteer with us now to pay forward the help they got. And they tell us all kinds of great ideas you can celebrate along the way, right? It's a long process. Make new memories. Celebrating your victories will give you emotional strength. Fire families have held groundbreaking parties, framing or stud parties where people write on each other's walls little messages and they get covered up, but they're in there. That's one example. People create art from salvaged materials. There's lots of things. So we're gonna wrap up talking about some troubleshooting and dispute resolution. We talked about the fact that you have 3 years to collect your full RCV, which means keeping track of those receipts, not leaving money on the table. We talked about filing a lawsuit. Before you do that, it's always a good idea to have filed at least one complaint with the Department of Insurance. It's awkward if you were to go to court and an insurance company were to ask you, how come if we were so bad, why didn't you complain to the Department of Insurance, right? You can say, well, I didn't know that I could. But it's just a good thing to do, right? We're not naive. We know that the California Department of Insurance is not going to give you a free lawyer. They're not the equivalent of somebody like the law firm Cantor and Cantor or any of our other law firm volunteers. They're not going to do that. It's not the same thing. They will help you resolve an impasse. They will can help you get an extension, but they're not going to get you full compensation the way an insurance lawsuit might get you, right? But filing that complaint with the department is important. They can't retaliate against you, and it's just a good practice, because as I said, this is about leverage, right? As Jacqueline was explaining, this is all about leverage. Couple of events we have coming up are Survivor to Survivor on Tuesday, August 22nd. Really good time around the anniversary to come to one of these forums. It's informal. You'll be on Zoom with from the comfort of wherever you are living, with people who have unique empathy, understanding of where you are. Then on August 23rd, we will be covering the mechanics of rebuilding. We will talk a little bit about avoiding problems, avoiding liens. So our Ask an Expert forum is a great place for you to go to get answers to questions. And Jacqueline, I think you are one of our experts, are you not?
I am.
Okay, well, thank you for that. So Ask an Expert is a great place to go. I see we have not gotten any questions in the Q&A. Here's the resource information for the Department of Insurance and their website. I want to thank our funders at the Golden State Finance Authority and the Rural County Representatives of California. And I want to thank Jacqueline. I want to give you a chance now, Jacqueline, to share anything that you think we missed in the course of tonight's webinar. That's a guidance that you give to your clients.
I mean, I will say one thing. I am probably the least litigious plaintiff's attorney when it comes to this stuff. The more that we can tell you to help yourself in the beginning, the less likely you are to have to file a lawsuit. Sometimes it's unavoidable though, right? Sometimes you've done everything that you can possibly do, and you've listened to this webinar and you've looked at the internet and you've communicated with the insured, and you just get to a point where there is a huge roadblock. And that's when we help people. So I just want to say thank you for having me. I hope this was helpful to everyone. My contact information is in one of these slides. So if anybody
actually, I think we need to put it in the chat because
okay.
I think it was missing from your slide.
Yeah, I'm pretty Googleable, but
yeah, well, I will say this on our website in our Find Help directory. And Carolyn, if you can go in there and find the link to our Find Help directory and put that in the chat. And you can even bring it right to Cantor and Cantor. There you go. There's Jacqueline's email address. Now we've just cut right to the chase. So I am so grateful to you, Jacqueline. And again, you know, we try to be even-handed and, you know, not push people in one direction.
yeah.
But I think people don't, you know, don't realize a lot of the time that there is such a thing as a contingency fee lawyer, that you can
Right.
hire somebody who will not charge you unless they get a recovery for you. And so
Right. And if we don't get a recovery for you, then you don't pay anything. So
right.
the risk is on the law firm to bring cases that they think that they could prevail on. So unfortunately, that makes the intake process substantial. So we have to look at your claim file and we have to talk to you extensively to figure out whether you really do have a good case or not.
Right. And so one thing I say to people all the time is there's absolutely no harm or risk in contacting one of the lawyers in our directory to get them to evaluate your situation. They're not going to charge you, you know, to give you a sort of a quick reaction to, you know, yes, that conduct rises to the level of bad faith, or it sounds like just kind of there's a, you know, dispute and they're just, you know, you're trying to work it out. They're going to be honest with you if they work on contingency, because they're not going to lead you down the path like somebody would if they were charging you by the hour and say, oh, sure, you can take a run at this, right? A contingent fee lawyer is only going to take a case that they think they have a reasonable shot at winning. So there's nothing, you know, you have nothing to lose by going to a lawyer who works on contingency and asking them to evaluate your situation.
Right. At a minimum, we'll give you some insight. Sometimes it's something when it's coming back and forth between numbers where we suggest that you retain a public adjuster, and we might have a referral for that. Or we say, hey, your case isn't for us, but we know somebody else who might be able to handle it for you. So it's certainly worth it.
Yeah. So we actually did get one question. Thank you, Rocky. And the question of how, if your mortgage lender, right, is holding up your insurance money, how do you break through that log jam? So very, very common problem. You know, if you have a mortgage, your insurance company is going to be named on your insurance policy as an additional named insured. They have kind of a lien, sort of an interest in your insurance because they, you know, they issued you a loan, and and the collateral for the loan is that you have insurance in case it gets damaged, right? So so Jacqueline, we have tips we have a sample letter on communicating with the lender. Generally, they want to know that you are actually going to restore the asset with the insurance money, right? That's their main thing. Any tips that you want to offer on dealing with a mortgage company that is holding on to your insurance money?
Yeah, this has come up here and there in my practice, and it's always the situation where a lot of times the insured, the one who's gotten the check, isn't really clear what's going on. So there's a miscommunication that happens between the insured and the mortgage company. And then you're talking to a customer service representative who also doesn't engage with this very often. So my first suggestion is, if you talk to somebody initially and they seem like they don't know what you're talking about, you need to keep going up the chain, because they just mess it up all the time. But typically in our practice, when we file lawsuits, we don't really see it very often.
Yeah, and that's another it's one of those things that the Department of Insurance actually can help in that situation. And that's one of those problems that they can they will try to reach out to a lender for you. But it is a very common scenario and frustrating. Anyway, so I want to thank you again, Jacqueline, for being with us, and remind you again that tonight's webinar has been recorded, and you would be able to watch it again if you want to. And our website remains a great resource. We go into all kinds of detail on what's a public adjuster, is it too late to hire one? What can I expect to pay if I hire a lawyer on a contingency? What is litigation like if I go there? We have guidance on that in our library, and we have our whole samples and examples library as well available. So I want to thank those who tuned in, and thank Jacqueline and her firm for being part of our work. Wish you all a healthy and safe rest of your evening. And thank you for your time and attention. Good evening.